Okay, the daughters of this man whose declaration I'm about to read you already confessed in court on August 19th, 2024, that they had never once spoke to their own father in 6 years of cancer. Okay? That would be these two licensed occupational therapists in California, one who works at UCLA named Flora Ziprin. She's the child psychologist for the faculty's children. And then the other one moved out of state and is living in Washington. And this man who wrote this right here, he died of cancer. And he said the daughters didn't see him in 6 years, so they could only get a quarter of his half of the home he lived in for 45 years, 1810 Grant Street, Berkeley, California, worth $2 million. The house next door sold for $2.35 million just recently. So Yehuda Ferris, as trustee of the Cancer Patients Trust, case number RP22120163, in violation of the irrevocable trust, sold the two daughters his half of the $2 million house for $82,000. But the trust says they can't own half. It's illegal. The trust says they can only get 25% each. And that from the other half, the cancer patient's three elderly Jewish siblings are supposed to get a lien on the property with interest until $90,000 is paid in full. Well, 5 years later, they haven't got a dime. And Yehuda Ferris is going to court trying to get a restraining order saying that the sibling can't talk to the media about the story because it's embarrassing him. But he's not embarrassed to God that he didn't give the three siblings but $4,000 when they're due $90,000. That's okay with him, but he doesn't want to be embarrassed about it by the media finding out. Well, I want to read you a declaration by the cancer patient before he died, when he sued to get back in the house, because this is very revealing. Okay, so let's get right down to the brass tacks. Okay, this is the attorney up here, William Rogers. He's taken $57,000 from this man's trust, but the siblings only got $4,000. And he sells the property to the two daughters, the $1 million worth of property to the man's two daughters for $82,000. The trustee and Will Rogers does this. But trustees are not supposed to be biased towards one beneficiary against the other. But here he sells the two daughters who never saw their father in 6 years the $1 million worth of real estate for $80,000. But then the man's siblings, who are supposed to get $90,000 plus 10% interest a year to split, they didn't get anything but $4,000. So that's bias, ladies and gentlemen. That's bias. So let's read on. Okay, it says Lee Ziprin versus Salgado, okay? Unknown property claiming interest in the property. I, the cancer patient, declares I'm the plaintiff in this matter. Copy of the complaint filed August 27th. I am co-owner with defendant Salgado of the real property, is the subject of the complaint, which is commonly known as 1810 Grant Street, Berkeley, California, 94703. Parcel number 057-2065-034, herein known as the property. Defendant and I are married, but prior to my ouster from the property, we lived together on the property for over 30 years. We have two adult children together. Those are the ones that just declared that they didn't see their own father in 6 years of cancer before he died. They just confessed under oath. You can look it up in the case number RP22120163. Defendant and I became owners as tenants in common of the property in 2000. Is a true copy of the grant deed. Before then, we had been renters of the property for 15 years. Since the purchase in 2000 to the present day, I paid one half of all mortgage. He probably paid he paid the whole thing. He's just pretending, because he built houses and she cut hair part-time. Who paid the mortgage on that one? Ask Ray Charles, even he could see it. Became due. The mortgage has been paid off. I have been making payments consistently, even though I have not lived on the property since 2011. In 2014, I was diagnosed with hepatocellular liver cancer. Exhibit 3 is a true copy of a letter from my treating physician, Daniel Brandman. I am not a candidate for a transplant due to the severity of my liver cancer. 3 years ago, doctors told me I had 1 year to live. In 2011, the court ordered a criminal protective order, domestic violence, ordering me to vacate the property. A true copy of the CPO and printout of the case information is attached as Exhibit 4. The incident involved a physical altercation between myself and my then 17-year-old daughter, that would be Flora Ziprin. Although I pleaded no contest to the charges, I was actually the party who suffered injuries, and you can see the photographs here. My daughter was a second-degree black belt in karate, and I was defenseless against her. I pleaded no contest for sake of family harmony. The CPO expired in 2014. Since that time, I have written to defendant at least 3 times politely requesting that I be allowed to return to my home. True copies of 3 letters are attached as Exhibit 5. Defendant has never responded to any of my letters. Moving right along to page 3. Defendant has changed the locks on the property and barred my access to it. I asked the Alameda County Sheriff's Office to assist me in gaining access to my home. The sheriff told me he would be happy to help me, but I needed a court order. Because I am living with a debilitating and terminal illness, I am limited in how much I can work. I've always been a house painter, and work was taxing physically, even though I was in good health. Since this is essentially the only skill that I have, and since I need some income, I continue to work to the extent that I'm able to. I am now forced to work at a much slower pace than I used to, and even with the slow pace, I tire easily. Because of my inability to be fully employed, I earn less than $2,000 per month. I have not been able to afford rent a decent place to live because of my income, especially since I was paying 1/2 of the mortgage and the taxes on the property. Currently, I am paying $200 a month to sleep in a basement in Oakland. The room has no heat and no means of cooking meals. There is no sink or shower or toilet, simply a faucet with cold water that empties into the floor and down a drain. There are no windows, and there's an inside lock to the door. The room is damp, dark, and moldy. When heavy rains come, water leaks into the floor. I am getting sicker and weaker and becoming worse because of the unhealthy and depressing conditions under which I am living. Yeah, his own daughters are making $100,000 a year as occupational therapists, and they can't even call him, let alone contribute to his living conditions. He's the one that brought him into the world. And yet the trustee gave him his half of the house in violation of his trust for $80,000 and left his 3 siblings starving to death. In the home that I own, the property, there is a separate room with a separate entrance that I can live in. The separate room is dry and has heat with light and would suffice to providing for my simple needs. Defendant and I would have to share a bathroom and a kitchen, and I would promise to be respectful and considerate at all times. I can understand the defendant does not want me I can understand back in the home. However, it's my home, and it's my right to live there as much as defendant has a right to live there. I'm willing to consent to a no-ham order. The Berkeley Police and General Order D5, a true copy, is attached there too. Highlighted, defines no-ham type of restraining order that authorizes involved parties to reside with each other. I do not want to bother defendant, and besides, I do not have the willpower or energy to interact with anyone, let alone bother anyone. If this ex parte request is not granted, I will seek an order for a speedy sale of the property so that I can use the proceeds of the sale to rent a decent home, a decent place to live. I am not the person I was in 2011 at the time of the CPO. The incident leading me up to the CEO involved one of the arguments that defendant and I would then engage. We were both under the influence of alcohol. I no longer drink alcohol or any type of recreational drug, not even marijuana. I don't even take sugar or caffeine. I'm deeply involved in my religious congregation, and I'm using the little energy that I have left after working to seek emotional and spiritual peace before I die. I am tired, weak, and dying. I do not deserve to die in a cold, dark, stinking basement. All I want to do is to be able to live comfortably and peacefully in my own home, the only home that I have known for the past 37 years, for the little time left to me before I journey into the great unknown. Then it says, this page is intentionally blank. I have personal knowledge of the foregoing, and if called as a witness, I would competently testify thereto, except in those matters if stated on information and belief. As to those matters I believe to be true, I declare under penalty of perjury in the state of California that the foregoing is true and correct. September 2018. Yeah, it's not signed, but here's a self-addressed envelope to the criminal attorney who stole $57,000 in attorney's fees from this cancer patient's trust and needs to be disbarred. His name is William J. Rogers. And it shows right here a self-addressed stamped envelope to him, and it's wrinkled right in the same place. So now, in 2025, what has happened is they have taken every penny out of the trust. They didn't give the three siblings a dime. They illegally evicted the brother who took care of his brother for 6 years. They threatened him with disinheritance if he didn't leave 3 years ago in the middle of the pandemic when it was illegal to move. Then they sold the property out from under him. Then he sued in court because the lawyers wouldn't take the case because it's $1 million or less, and trust litigation attorneys don't want small cases, and they're too busy with billionaires who died during COVID. And the probate court got written up by the Alameda County grand jury as overcrowded and no oversight. And the judge set a trial for August 19th, 2024, and the sibling couldn't get a continuance and he couldn't get an attorney. So he logically, like anybody else with common sense, he dismissed without prejudice 6 out of 7 of his petitions so he can bring him back later. And then there was one that he couldn't dismiss and he faced it. He lost, and it's on appeal. But then Briar Horn lied to the court and said that he filed 29 lawsuits in the last few years. The sibling objected and said, no, it's only 4. And then the judge turned around and declared him a vexatious litigant anyway, based on the lies of Briar Horn. And Yehuda Ferris and William John Rogers joined in the motion. So now they blacklisted the brothers, the cancer patient's brother, so he can't file any lawsuits because no lawyer is going to take a case when the guy's a vexatious litigant, and the judge won't let him file his own case. Not in Alameda County, the judge here won't let any vexatious litigant file anything, ever. It never happens. And if that wasn't enough, now they're going to try to get a civil restraining order saying that the sibling shouldn't be able to talk to the media about this story. Okay, you heard it first. This is the manifestation of and personification of evil.